Hello. Uh, Hi everyone. This is Mansi from Turnip Innovations. Welcome back, everyone. And now we have our third session that is by Ms. Shravani Deshmukh and Ms. Yasheshwini Oja. They are the co-founders at Create and Protect IP Partners and are leading young lawyers who aim to promote the importance of intellectual property in the creative industry. Get compelling insights on copyrights with them with the two master classes that they are hosting. One will be today and the other will one will be tomorrow at the same time. So stay tuned, and yes, they are here to help you out. You can ask them anything in the comment section.
Hello everyone. Good afternoon. First of all, we are Yashashwini and Shravani, and we will be taking the session on deep dive into copyrights. The session will be, as Mansi has already mentioned, into two parts. Today will be one part of the section that we'll cover, and we'll continue it tomorrow. And we hope that it's engaging and interesting for everyone.
Yeah, and please don't, please just make sure you ask us any questions. Don't hesitate. We are here to help you, as Mansi said.
So the basic roadmap for today's session will be, we'll do a little recap of the one webinar that we have already conducted on copyrights, and then we'll move on to today's session, which will be subject matter of copyrights, ownership in copyrights, the term of protection in copyrights, and copyright versus design. Now, this copyright versus design will obviously be taken over to the next session tomorrow, and then we'll continue from there. We'll obviously mention that next.
So let's start with a recap. This will also help you from a primary base of what copyright is. So what is a copyright? And please let me know your definitions in the comment section. But copyright is known as the creator's right. So basically works that come under literary, dramatic, artistic, these kinds of categories can be protected with respect to copyright. Now, if we talk about copyrights, it's also a bundle of rights. So what happens is not just the protection, you get an opportunity to adapt your work, you get an opportunity to reproduce it, and things like that. The second point, its existence versus registration. So a lot of you might have this question that, when does it start existing, and when what happens when you actually register it? So the existence starts the moment you start expressing it in a medium, which is obviously accessible to you, and the day you started. So for example, today, if I start writing a book with Shravani, from today, our copyright exists in that book. However, that existence is not as good as the registration, because then not only does it protect you, but it gives you an opportunity to reproduce, go ahead and create it in different forms of expression. The kinds of work. Coming to the kinds of work, there are a couple of subcategories in copyright, which is the kinds of work we'll be dealing with. There's literary, there's dramatic, there's musical, artistic, sound recording, cinematographic. So the different works come under this. And if you have heard the categories properly, you can see it's just creators who would come under this, but there is also a commercial aspect to it. We would definitely discuss that later. One big question: why should you protect the work if it already exists, if the copyright already exists? I think creativity is the cornerstone of our society, and social and economic development go hand in hand with creativity. So let's protect our copyright. Let's register our copyrights and make sure that we have an encouraging environment when with respect to creativity, like less copying, more creativity. So that's the recap.
The next part of the recap is the practical aspects of copyright that were there. One of the most important under these exceptions of copyright is fair use or fair dealing. It's a major exception that comes under copyright, because at the end of the day, what is copyright? It is your right to copy. So when do you actually have the right to copy? That is what fair use and fair dealing is. In some cases, like right now, for example, if we play a music from some movie, that will come under fair use, because we are not monetizing on that. We're not gaining any profits out of it. So as long as you don't gain profits out of that work, it will come under fair use. So that is like the main prerequisite for fair use. Then comes the Creative Commons. Creative Commons is like a worldwide organization which gives you the license, which gives creators different forms of license to give their works out. It can be a paid license, it can be an unpaid license. Sometimes you just have to take permission from the author. Always have to take permission and credit the author. So Creative Commons license will give you all of that under one roof. It will give you different kinds of licenses to give out to people. And finally, the registration process. We briefly took you through the registration process, which will include what are the documents required for registration and how do you go ahead with it. So this is the brief recap of what we did in the last webinar. Moving on to this session.
The last webinar can be found on Turnip's YouTube page if you would like to access it, because that's again a primary webinar. Coming to the subject matter of copyrights, one of the main topics of today's session. Obviously, I've briefed you the kind of works, as mentioned in the slide as well. These are the kind of works that come under the copyright aspect, and these are mentioned under section 13. We start with literary works, one of the most common ones. Literary works has certain criteria of things that are there, and with respect to these criteria, expression, aesthetic, and measure of skill and creativity. Now, when you're obviously expressing let's say I am writing a book with Shravani, my mode of expression would ideally be I'd probably type it out in the laptop, right? So expression should be original. If the idea is not original, the form of expression, it should originate from the authors. It should come right from the authors, right? So that's where the originality aspect comes into picture. Aesthetic, skill, and creativity. Now we all know the three of these are subjective. So for me, aesthetic could be something else. For you, it could be something else. For me, creativity could be something else. For you, it could be something else. So definitely there is an aspect that there has to be certain aesthetic and skill and creativity to it, because it is a product of human mind, right? So that will be there, but there is no standard that defines ki, acha, this is aesthetic or this is skill or creativity and this is the level we should be at. So that's one thing. That's the element. So whenever you are writing any sort of, let's say, copyright, any work which is coming under any category, aesthetic, skill, and creativity are dependent on you, and there is no measure of skill to define it. Then there are two types of work when it comes to literary. There's primary and prior works, and secondary and derivative works. So primary is something that is not originated from something existent in the market, and secondary is usually, let's say, an inspiration from something that is present in the market or a subject matter that you've taken up. With respect to literary works, there is one very important doctrine, that is test, that is the test of originality. What happens is, usually when we talk about originality in copyrights, the expression of your work is more important than the idea. So when we are talking about originality, is not about that the idea should be original, because ideas cannot be copyrighted. What should be original is the way you are presenting it, like the way you have been putting it in a medium. It has to be put into a medium to be copyrighted. You cannot go ahead with an idea and just copyright it. There has to be exact details to it, right? And the debate of originality and novelty. Whenever intellectual property rights is discussed, novelty is one aspect that comes into picture, and obviously a lot of people would say both of these terms are synonymous. But with respect to the Copyright Act, the basic principles is that expression matters more than the idea. So your expression has to be clear, and it has to originate from you as an author. It cannot be something that has already been done, right? So let's move to the next slide. Copyright and themes and ideas. As I mentioned, ideas and themes cannot be copyrighted. You cannot go ahead and copyright an idea, because there has to be a subject matter to it, right? If, for example, clinical trials, if I go ahead and copyright the idea of clinical trials, it becomes a monopoly. Nobody else can create anything on clinical trials because I have gone ahead and copyrighted it. So for an idea or to be copyrighted, it has to be, brought down to those details. Like, let's say a movie on clinical trials. So my entire script and the way my script goes can be copyrighted, and then nobody else can create a similar script. But obviously somebody can create another movie on clinical trials. That's the idea in public domain. You cannot copyright it. Now the conflict which comes with respect to protection under copyright is over and under protection. So it's creating a balance of interest, because if I go ahead and copyright something as huge as clinical trials, a concept like this, it's in public domain. It's basically giving too much protection to an idea. and not giving a script of clinical trial the chance to get copyrighted is under protection. So to balance it out, Copyright Act basically creates a place wherein you can go ahead and don't put your idea on paper, and then probably it can be copyrighted. Copyright in concept notes. So I'm pretty sure everybody is aware of this concept called Swayamvar. It happened, I think, 5-10 years ago on TV. It was like a huge thing on reality TV. With respect to that, concept notes, again, concept notes in themselves cannot be copyrighted. But there is this case which addresses the Swayamvar concept. What happened is the producer of that show went ahead and copyrighted not the idea, but the entire, the manner in which the show goes on, and named it Swayamvar. Calcutta High Court, when somebody else tried to copy it, and he obviously went ahead with legal proceedings, Calcutta High Court said that because he's put it into a tangible medium, he's written down everything to the exact detail, what exactly happens in that show, each and every step. That's why he has been granted the protection for that idea, and it actually came out of him. It was something that originated from the author, that acha, something like Swayamvar can be a TV show that can be scripted. So that way. So that's how concept knows ideas and themes work. It's better if it's to the detail, and then you go ahead and copyright it. Coming to computer programs and copyrights. So computer and computer programs both have been defined in the Copyright Act. And with respect to websites specifically, that front end and back end of websites is copyrightable. Now, what is front end and back end? So front end is basically what the users see. So the front end of the website is what you can access, you can see when you're scrolling down the website. The back end is the admin who's creating, or the coder, whoever's is creating the entire website for you guys to be able to see it. With respect to computer programs, they come under literary work for a reason. That is because you can write codes, you can write flowcharts, you can come up with, let's say, a specific code which you can register as a copyright. And the originality requirement is really less here, because obviously every code will differ, every kind of idea or literary work with respect to computer programs would differ. So softwares and databases, these all come under these aspects. The originality aspect of it, there is no requisite ki acha, this is the level of originality. It differs from author to author. And generally, computer programs, because being a compilation of literary work, because they're reduced into literary form, are copyrightable under literary works. Coming to the next slide.
Next, we will be dealing with original dramatic, musical, and artistic work. Now, under all of these categories, there are different subcategories which have particular subject matter that is obviously protected by copyright. Now, I'll be dealing with all of those subcategories very briefly, but to give an idea, all of these will have specific limitation in the kind of protection that they get. Starting with original dramatic work. What is a dramatic work? A dramatic work can be any mute performance for entertainment, any choreographic work, or any arrangement where there is no need of words. So only the mute performances which are used for entertainment purposes, those are the ones that come into dramatic work. That's why cinematograph films doesn't come under dramatic work, because it's a combination of not just scenic arrangements but also dialogues. It'll get a complete whole different protection under copyright. Now, under dramatic work, two things that I'll be dealing with majorly is choreographic arrangement and scenic arrangement. Now, what is a choreographic arrangement? It is a dance form. To get protection for choreographic arrangement, you need to put it down in some fixed medium. I mean, that is a prerequisite that Yashaswini has also mentioned. To get copyright protection for a particular work, you just need to put it in a physical form, a medium that can be communicated to people. The only problem with choreographic work, which is also kind of a big debate right now, is putting down a choreographic work in a graphical notation is extremely expensive. There are two main ways in which it is to be done, but those ways are really expensive and not very feasible to do. So usually when I choreograph a piece of, say, dance, I cannot just write down one step to the right or one step to the left. That will not be original. That will be like every dance form is like that. At the same time, I cannot afford to really get get it graphically noted. So it's kind of a dodgy area over there, but there is, in as per the act, you do have protection for it. Coming down to scenic arrangements, now scenic arrangements are again play or anything which is mute again, and it can be in the form of acting, it can be in the form of dancing, anything, but the substantial part over here is that it has to be mute. And those theaters, those plays, if they're put down in a graphical notation, or if they're put down in any physical medium, they will get protection under dramatic works. Coming down to musical works, now musical works is again different from sound recordings. Musical works is just the tune that you hear. So if a song is playing, the tune that is going on behind it, that is what a musical work is, and the composer of that tune will graphically note it down. So that's also easy to do, because people usually who have learned music, they also know how to graphically notate all of these musical works. So original musical works will only be the ones that's the tune going on behind a song. The tune with the words will again be a total different protection that will be under sound recordings. Coming down to original artistic work. Now, artistic work is a huge field in itself. There's a lot of things that are covered under it. I'll deal with them very briefly, but just to give an idea of what each one is, I'll tell it. In terms of painting, now painting and drawings are two different subject matters in artistic work. Why? Because painting is only considered as a combination of colors, while a drawing is a drawing with lines or anything. So that is why both of them will be treated as differently, and both of them will get different protection, but under artistic work. So painting will be a combination of colors. Engravings, very interesting. Engravings are wood etchings or wood carvings that happen, and these were one of the first artistic work that actually got protection under this act. So engravings will be not just the engraving that you do, not just the image that will get protection, but even the plate on which it is done. So engraving, the whole thing, if it's a piece of wood, I've etched out something off of it. So that's why the whole thing will be protected under engravings. Sculpture, very self-explanatory. We Indian festivals have a lot of gods and goddesses and sculptures. So the sculptors, as soon as they use it can be made of clay, it can be made of wood. As soon as they make that piece of clay into a sculpture, they get protection. The protection for their copyright starts from that point. Drawings and maps, as I already mentioned, drawings are just your normal drawings. It obviously cannot be just a flower. You won't be getting protection for that. It has to be something original. Now maps will not be a map of India. That's not original. A map will be, say, if an architect has drawn a map of a building or anything that is inside a huge building, that will be a map that can be protected. That's original work. Photograph, again, very self-explanatory. Your photo will obviously be protected. The moment it is printed out, it is clicked and printed out, it will be protected under copyright. Work of architecture, again, very interesting. Buildings, the whole design of a building can be protected as work of architecture. But the composition of that building, the method of construction of that building, all of those will not be under the subject matter of artistic work. That is a whole different protection that you will need. But work of architecture will just be the design of a building that you have. Last is artistic work of craftsmanship, which is also gaining a lot of importance right now, especially with handicrafts. So if an artisan is making something out of like scratch, basically, say from cotton to a proper textile, that whole thing, the final product is an artistic work of craftsmanship. So that is what you'll get protection for. So these are all the works that are actually covered and protected under copyrights.
Next, we come to ownership. So, what is ownership? Within the concept of ownership, there are a lot of works where a lot of people are involved in making those work. Let's say cinematographic work, or let's say music. Even in art, there are times when a lot of people are involved. So, who has the ownership when so many people are involved in creating this work? So, let's look into that with respect to cinematograph work. What happens is, with respect to the script of any movie, the author who has come up with the idea, where the author is the person who originates with this idea and writes it down, right? So he becomes the owner of the copyright, and producer is somebody who takes the initiative of creating an entire movie with it, creating the whole work and presenting it to the audience. So the major owner would be the author. With respect to sound recordings, obviously the producer of the work. And when we talk about producer, it does not just refer to the financial responsibility a producer has to make sure that the track is recorded and it's published, but also any legal steps that are required for the producer to take. And usually the legal steps does have an important intellectual property rights responsibility, because for music especially, a lot of recently in India and for years now in abroad, people are taking music seriously, and the musicians themselves are trying to get protection as much as they can for their ideas and their work. So that's one thing. Then we go to government and international organizations. So government work, again, if the government is the would be the first owner, until and unless there is a contract with somebody. A lot of times, individual inventions, the government takes a contract. So when it's an individual invention, suppose Shravani has created something that is really good for the government, so Shravani will have the she's the owner of the copyright, but the government is just taken it on a contract to use it, right? So Shravani will have it, or else it's always the government. Again, it could include any department of the government, legislature, court, tribunal. Government would include that. Ownership in international organization. With respect to international organization, obviously, which is something that is made under the direction and control of an organization, the rights for that it vests with the organization. Again, there are chances that some individual inventor come up with it, and you guys do a contract, but usually for international organizations, they are the first owners of the same. In continuation.
Yeah. Next is ownership in literary, dramatic, artistic works, musical works included. So, one rule of thumb for ownership is that the author of the work is the first owner. First ownership is very, very important to be established, because whenever there is a dispute, say in terms of who owns the copyright, or who has the copyright, who made the copyright, it is the point of contention is always ownership. It always falls back to ownership, and that's why it's very important to register your works. The moment you register it, you have a proof of ownership, and that's why also it's very important. People think that as soon as I create a work, I will be the owner of the work, but at that same time, you need some proof to prove that. Prove that proof, and that's why it's very important to register. Now, again, in ownership in literary, dramatic, artistic work, the main author of that work will be the first owner of the work. Again, in musical works, it will be the author, which is the composer in here, which makes the tune of the work. He will be the first owner of the work. Copyright and ideas and joint authorship. Now, for example, if I have an idea to write a book with Yashaswini, and I just tell it to her, but I did not really act on it, Yashaswini will go and maybe write that book and get it published. Now, I cannot here contest that I am also an owner in that book, and or I should be the first owner of that book, because I did not put it down in any medium. She was the one who actually went ahead and put it down on a medium, and that's why she will be the first owner of it. As was already covered by Yashaswini in subject matter, ideas cannot be copyrighted. Anyone can have any idea. The more important part over there is to put it down in a physical medium, any form of physical medium, or express it in a certain way. So there, obviously, copyright is not available in ideas. Now, in terms of joint authorship, what happens is when two works, especially now, taking the same example forward, if Yashaswini and I are writing a book, and she has written the whole entire book, and I just gave some experiences and told her my experiences, that will not amount to me being a joint author in that book. Why? Because the contribution of both the authors here should be same. It should be equal. It should not be distinct from each other. She clearly did more work than I did, and that's why she should be the first owner of that work, and I will not get joint authorship over here. Again, there was a really interesting case over here where some really famous person gave full a monologue about his experiences in life to a journalist, and the journalist put that down on paper. He released it in the newspaper, so the credits were not given to the famous person, and he contested that, because saying that, okay, I was the one, this is my story, so I should get joint authorship over there. But again, the court decided otherwise. There was distinction in work, there was no equal contribution in that work, and that's why he did not get joint authorship for that work, even though it was his own story. Next is copyright in lectures and addresses. Now, like this is a lecture here, a person who delivers will be the copyright owner. And if I am delivering on behalf of Yashashwini, then again I will be the owner, because I am putting it out in that medium. I am putting it out in that, the expression is me putting it out outside. So ownership here will be the person who delivers the lecture.
Don't copy.
Ownership in terms of computer programs, again, the person who creates the work will be the owner. Now here it's interesting because say if in a company I am employed as an accountant, for example, and I know how to do some computer programming, and if the employer asks me to go ahead and do the computer programming, I will be the owner of that work and not the employer, because I am doing it outside of my duties. My rights of duties was to be an accountant, not a computer programmer. And I went outside of those duties, which will not be protected as a company by the company. And that's why I will be the owner. Otherwise, obviously, if you are an employee of that company, the main owner of the work will be with the main company. Now here, that's why it's very important to understand contract of service and contract for service. Two very different things. Contract of service is like an employment contract. So if Yashashwini is a CEO of a company, she employs me and asks me to do a certain kind of work. I will, and as I am the employee of that company, I will create that work, but that work is used for the business. It is an integral part of that business, and that's why she who's paying me will be the first owner of that work. Moving on to contract for service. Contract for service is like an independent contractor service, or like a freelancer. A lot of people are freelancing today, and that's why it's very important to know what a contract for service is. In contract for service, what happens is I am an independent contractor, and again, Yashwini has employed me out of the actual employees pool, the pool that she already has. She has employed me from outside and has asked me to do a certain work for the company. Now, even though that work will be used for the company, it's just an accessory. It's not an integral part of that company. And I'm not the employee of her. I'm not an employee of hers. So she will not have direct control over my work. My work will be my work. It will be I'll be the first owner of that work. So that distinction needs to be established whenever you are doing work for someone, if it is a contract of service or contract for service. Next, we move on to the term of contract protection.
So, with respect to the term, obviously, the term, is it perpetual, is it limited, and if there is a timeline of protection, why is it in place, right? So let's talk about first the fact that is it perpetual or limited, and if there are any guesses, again, put it in the comment section. For copyrights, the term of protection is limited, for the reason because there has to be a balance of interest in the society. What happens is, a lot of people say that copyright protection should be permanent, because again, the public is enjoying the art or the movie or whatever it is, it should be permanent. And a lot of other side of the population is like, okay, but if the author dies, it's a personal right? She has published a book, and if the author dies, then it should terminate with the death of the author. To create a kind of balance in both these views, the legislative intent behind giving a limited protection was to also ensure that a permanent protection would be sort of an overprotection. And if you just do it like saying death of the author and the copyright is over, that is also disrespectful for somebody who's worked so hard to create something. So section 22 talks about the term, and I'll address the term later, but let's first talk about joint ownership and its term. So what happens is, in joint ownership, let's say both of us have written a book, and I don't want to say that, but okay, let's say by the death of the second author, the term continues post the death. So for the term of copyright is basically the lifetime of an author plus 60 or 50 years, depending on what the work is, of protection. So let's say we write a book, and after us, it will stay for 60 years, right? And that is that is considering that one of us dies later. So if that happens, then post the death of that author, 60 years. Copyright protection in case of anonymous works. Now there are a lot of people who do not want to come out with their their, yeah, they don't want to mention the art or the kind of work they have done, and they have anonymous protection. However, there are chances that their name might come out. So usually for anonymous work, it is 60 years, but just in case the author is revealed, then obviously till the lifetime of the author, and then 60 years. We'll look into some of the specific works and how the term works around these works. So literary, dramatic, music, artistic, cinematography, and sound recordings. For all of these works, lifetime of the author, that is, when till the life of the author, and 60 years from the beginning of the next year, right? So that is for all of these works. For government works and works of public sector undertakings, international organization, it usually is 60 years from the next year, the year from the next year the record is published. So let's say in 2020 the record is published, the protection starts in 2021. If we create a book in 2020, and let's say post 2065 we passed out, so it'll be post that time, 2065, 60 years from that time. So that is how protection works. Another interesting thing about the term of copyright protection is that it is not creating a conflict in what the creators, or let's say the society at large thinks, because again, if we look at the two arguments, permanent and personal right, it is kind of extreme if we look into it, that having a personal right to it, and the moment somebody passes away, their entire hard work goes away. That's not good. And also having a permanent right is basically creating a monopoly in a certain idea which might just be the future of this country. So that's why to create like the balance, this is like the perfect term. And yeah, that's about it. I think no, that's one more topic, I'm sorry. Copyright versus
Design. Now, a lot of times when people come to us, one of the most popular question, so to say, is whether to register your work as a copyright or as a design. So it's a very debated topic, so to say, but both of these works are very distinguished from each other, very different from each other, and the rights that you get from these are also very different. So copyright, we have already seen, it's a creator's right, and you get protection for the work that you have made when it's put in a physical form. That is what a copyright is. Again, originality is the only and main aspect over here that you have to check that box. That's it with copyright. Now, what are designs? Designs are, say, a combination of patterns, colors, lines, colors, which can be in the form of two dimension or three dimension, or a combination of both. But when you get protection for a design, you only get protection for the outer look of that design. There is nothing inside. The composition of the design obviously will not be protected under design. So for example, this laptop that we are looking at right now, just the external appearance, the look and feel of this laptop is what will be a design protection. Whereas in the copyright, it will be something different. It will be drawn by hand. It is literary work that you do. And that is why you get protection for those works separately. But in design, just the outer appearance of that particular design, that particular work is what you get protection for. Now, with design, there's obviously it has to be original, but as was mentioned by Ashwini, the original and novelty, the difference between the two is where here in design it has to be novel. There has to be, the design has to be a little different than what is already there. In copyright, the idea can be same but expressed it differently. But the base idea of that whole work is same. In design, on the other hand, it has to be novel. It has to be something different. It has to be something that is not already in the market. So that is the main difference again between the two. Not just original work, it has to be novel. It has to be functional also. It doesn't have to be anything really complicated for the users to use. So these are some of the things that have to be mentioned when it comes to protection under design. Whereas in copyright, you don't have all of that. You just have to put it in a fixed form, in a fixed medium, and you will get ownership on that. So those are designs. So and that is the major difference between copyright and design. Again, copyright is an inherent and personal right, as she mentioned. As soon as I put something down in a medium, I will get protection from it for it. My protection starts right there. But for design, you have to register it. It's one of the prerequisites to actually get protection for that. Now, different kinds of legislative intent and all of those things will be dealt with by Yashaswini tomorrow in tomorrow's session. But here we leave you so that you guys come back tomorrow and we continue this discussion on copyright versus design and many more interesting topics related to copyright.
Yeah. We don't want to overload you with a lot of copyright information.
Yeah.
That's why I think we'll take a couple of
questions. Maybe we'll see. How to obtain copyright for mobile apps. For mobile apps, again, if it's written down in its code, the code of a mobile application, for example, you can go ahead and copyright that under literary work, and that is what you'll get protection for. If the interface of that is not very unique, you might not get protection for that. But the coding, yes, it will get a protection. The debate question by Anvesha. Why would work of architecture, that is the design or layout, be included under artistic work and not design? Very interesting, yes. Work of architecture, again, you can get protection in both, but its functionality is also one of the major ticks that you have to check when it comes to design protection. Functionality in a building, it's very difficult to prove. Obviously, you will be able to prove because you live in it or you use it for a certain thing. But functionality, which means, again, this laptop functionality, is it's easy to carry, it's easy to use. So that is one of the ways that you can distinguish.
And also, I feel like it's also depends upon the because it cannot overlap together. If you have it in copyright, you cannot also have it in design. But the fact, it also depends on the author, the kind of work that is involved. Like Shravani mentioned, it could be something, it could just be a design or it could be a functional design. So looking at, let's say, the pros and cons of your work, you can probably decide what to choose.
Yeah. Anything else that we have? I think we've covered the questions.
Yeah.
Yeah, I think
that's about it. We'll conclude it. So we hope the session was informative, and if there are any doubts regarding the session, you can always contact us. You can always drop in your questions in the comments. I think we have a minute or so. So if there's still any questions, please go ahead and thank you so much for
thank you. And you can go check the link also in the description that will be mentioned.
Yeah.
If you have any questions over there, you can go and approach us. And probably we'll hopefully be able to help you out.
Because the question, the idea of this is absolutely to make sure everybody is aware of, this extremely helpful creators, right? So I think it's important that in a country like India, you are able to protect the creators. They also form a part of the economy.
Yes.
And I think that's why we are trying out. Thank you so much, Pratyusha.
Thank you, Pratyusha.
Thank you, Mr. Kannan. Anvesha. I think
Ms. Gargi also for your question. Thank you so much.
Thank you, guys. Thank you, Mrs. Aditi Deshmukh.
Yes. So we'll hopefully see you tomorrow.
Yes.
And it'll be a very interesting session.
Yeah.
And we have a little takeaway also. So please hang on to that.
Yeah, stay tuned. It'll be a really interesting session.
Yes.
Over to Mansi.
Yeah.
Thank you. Thank you so much, Ms. Shravani and Yashashwini. It was an amazing session. Really enjoyed it. Thank you for all the knowledge. Thank you so much. We'll see everyone for the next session at 4 by ITTO. Thank you so much.
Thank you, Mansi. Thank you so much.
Okay, so here they were, and now we have the next session with ITTO. Ms. Pragati Agarwal will be there to guide you on fundraising. So yes, make sure that you join her session. The link is in the comment section as well. And yes, thank you so much, everyone. If there are any questions, you can post it in the comment section. We'll get back to you. Thank you so much.